The question is that the bill stand as— oh, sorry, Senator Xenophon.
Thank you very much, Acting Chair. To the Attorney, I have some questions. Looking at the transcripts of the Prime Minister, statements given by the government, the emphasis in this legislation has been about terrorists fighting with the Daesh death cult, to use terminology from the Prime Minister. And I'll go very quickly. A transcript of the Prime Minister, the then Prime Minister, of the 22nd of January 2015 talked about, we can't take away people's citizenship. What we can do is to ensure we stop them from going in the first place. That was in the context of the foreign fighters legislation, so I understand that. But later there were, subsequently, when the citizenship, this legislation was being discussed, the emphasis was very much about people involved in terrorist activities, with serious terrorist-related activities. In fact, the joint press release of the then Prime Minister and the then and current Immigration Minister, the Honourable Mr Dutton, made reference in a media release of the 26th of May 2015, saying that the Minister for Immigration and Border Protection will be able to exercise these powers in the national interest where a dual citizen betrays our country by participating in serious terrorist-related activities. Transcript of the Prime Minister's statement, then Prime Minister's statement, with the Honourable Mr Dutton, indeed yourself, Attorney, where the reference was made repeatedly about serious terrorist threats. And I won't be prolix by repeating it unnecessarily, but the statements of the government, the Prime Minister, the Minister for Immigration, indeed yourself, were that there was a real emphasis about having your citizenship stripped in respect of being involved in a terrorist threat. My concern is this. My understanding is that the legislation does actually go far beyond that, and I've made this clear. I think I've given fair notice to your office, Attorney, as a courtesy to you, the usual courtesy, that my concern in relation to the application of section 35A1A3 of this bill makes reference to other offences. One of those offences is section 91(1) of the Criminal Code that relates to espionage. I won't insult the Attorney by asking him to confirm that, because it's on the face of it on the bill. My concern, Attorney, is this. In relation to the proceedings in the International Court of Justice in The Hague, at a public sitting on Tuesday the 21st of January 2014 at the Peace Palace, with President Tomka presiding, and Australia was well represented by a legal team headed by Mr Justin Gleeson, SC, the Solicitor General of the Commonwealth. At paragraph 32 of the transcript at page 17, and this relates to a dispute between, it's a case, reading fairly from the transcript from the International Court of Justice of The Hague. It relates to a case concerning questions relating to the seizure and detention of certain documents and data at Timor-Leste and Australia. And this relates to the raid on the 2nd of December, I think it was, 2013, of Mr Bernard Caleri's offices, his chambers, and involves witness case, something that we've ventilated on many occasions in estimates and here in this chamber. Mr Gleeson, SC, the Solicitor General, as part of the case, said, on the basis, however, of what I've just taken to you, there are reasonable grounds to consider that the materials over which Timor-Leste asserts privilege may include written statements or affidavits by a former ASIS officer made to Mr Caleri on behalf of Timor-Leste disclosing national security information of Australia. If that be the case, those disclosures would involve the commission of serious criminal offences under the law of Australia, and I reference sections 39 and 41 of the Intelligence Services Act 2001, section 70 of the Crimes Act 1914, and section 91(1) of Schedule 1 to the Criminal Code Act 1995 Commonwealth, which you have at tabs 20 to 22. So I've just wanted to put that in context. I guess to my direct question is this. The legislation has been framed in terms of the public discourse very much about terrorist-related offences, being involved with Daesh or ISIS. but it actually extends beyond that. It actually includes references to section 91(1) of the Criminal Code, which relates to espionage, and there appears to be a suggestion in relation to the statement that I've read from the transcript of the proceedings in The Hague, in the case involving Australia and Timor-Leste, from the solicitor, from Mr Justin Gleeson, SC, that on the face of it, it appears that there is an assertion that either the former ACIS officer referred to, known as Witness K, whose identity is quite appropriately suppressed, or Mr Cleary may have committed an offence under section 91(1). My question is, given the circumstances of this matter, which are contentious, and the ABC's Late Line ran a series of stories on this, does this legislation mean that potentially, if Mr Cleary or Witness K were convicted of section 91(1), and I must emphasise that Mr Cleary is quite distressed at any suggestion that he has done anything wrong and regards himself as a patriotic Australian, but if there were such a prosecution, could it apply in a case such as this, so that Mr Cleary, for instance, could find himself stripped of his Australian citizenship because he is a dual national, as I understand it? So I just wanted, I think I fairly set out my concerns.
Senator Brandis.
Well, Senator Xenophon, the legislation applies in the circumstances that are set out in the bill. It applies to those species of conduct defined by the Australian criminal law and referred to in the bill. In relation to the Cleary and Witness K matter, I know there's been a lot of public discussion about this lately, and I know that you are engaged in that discussion. I saw the Late Line programs last week. I made a statement to this chamber the day after the search warrants were executed 2 years ago. So if it was the 2nd of December, then it would have been today would be the 2nd anniversary of me making that statement. And I refer you to the statement. But beyond that, I don't think it would be appropriate for me to, and I certainly don't intend to, comment on that case.
Senator Xenophon.
I appreciate the attorney's answer, but it seems to me that this legislation that has been framed fairly and squarely in the public arena by the former Prime Minister, by our Immigration Minister, by the Attorney General, actually goes way beyond dealing with terrorism. It actually extends to section 91(1) of the Criminal Code. And there is reference in the proceedings in The Hague that potentially Mr Cleary, Witness K, could be in the firing line of section 91(1). That is the assertion that is made by the Solicitor General of the Commonwealth of Australia. So does the attorney concede that the legislation can apply in a case such as this, given the reference made by the Solicitor General, that an eminent Australian, a former Attorney General of the Australian Capital Territory, could face losing his citizenship if there was a prosecution brought under this legislation, if passed, under section 91(1)?
Senator Brandis.
Well, Senator Xenophon, as I'm sure you know, no prosecution has been brought against Mr Cleary or Witness K, and I'm just not going to be drawn on a hypothetical. I'm just not.
Senator Xenophon.
I need to frame this very carefully because I don't want to give up my sources, but can the attorney give an undertaking, give an assurance at the very least, that it is not contemplated that there will be proceedings against either Witness K or Mr Cleary that could lead, when this legislation is passed, with facing the stripping of their citizenship if either of them is a dual citizen, and I understand that Mr Cleary is?
Senator Brandis.
I'm sorry, Senator Xenophon, I'm not going to comment on a hypothetical case, nor am I going to be giving assurances to the chamber in relation to a matter in which primarily the Director of Public Prosecutions would decide whether or not a prosecution should be brought. I've told you, and I think you know this, that no prosecution has been commenced against either of those people. And in those circumstances, I think it would be absolutely inappropriate for me to comment.
Senator Xenophon.
Through you, Chair, I appreciate the attorney's comments. Whilst it may be, I don't think it would be. I wonder whether the attorney considers it appropriate to comment as to whether there have been any assurances given to any parties that this legislation is not contemplated, not intended, or not envisaged to be directed against witness K or Mr Cleary.
Senator Brandis.
Senator Xenophon, no Act of Parliament is written for the purpose of penalising identified individuals. Acts of the Australian Parliament are written for the purpose, or where they involve the application of the criminal law or sanctions. Acts of the Australian Parliament are written for the purpose of defining certain offences and penalising certain conduct. They are not ad hominem. They apply to all Australians.
Senator Xenophon.
Whilst, of course, they're not ad hominem, and I appreciate that, attorney, for reminding me of that, and it's fair that you do so. But isn't it not the case that your consent would be required for any prosecution under this section?
Senator Brandis.
Yes.
Senator Xenophon.
And can you now categorically rule out that you would not that you, as attorney, I don't know what any future attorney is, but by the looks of it, I think you might be attorney for a very long time in this place. Would you, as attorney, consent to a prosecution being brought against Mr Cleary or witness K?
Senator Brandis.
It would be absolutely wrong of me to give you any assurance about a hypothetical case in which no prosecution has been initiated.
Senator Xenophon.
Thank you, Chair. Respectfully, through you, Chair, this is not a hypothetical case. This very matter was raised by the Solicitor General of the Commonwealth of Australia, Mr Justin Gleeson SC, in The Hague, in the International Court of Justice, on the 21st of January 2014, where clear reference was made to a potential breach of Section 91(1) of Schedule 1 to the Criminal Code, one of the very sections that is captured by this legislation where a person can be stripped of their citizenship. And we know, through you, Chair, of the circumstances of this matter in terms of the serious allegations of the bugging of the East Timorese Cabinet Room during sensitive negotiations over the Timor Gap oil treaty back in 2004. We know that officers were raided on Mr Cleary. We know that this is a matter that is going to the International Court of Justice in terms of an arbitration, or it appears that it's headed that way. So I am concerned that such is the scope of this bill, and I understand the scope in terms of terrorists, and there's an argument as to what is the most effective way of dealing with it, if you can, and I'll ask those questions down the track. But I'm deeply concerned that the attorney cannot rule out that there will not be a prosecution against Mr Cleary or witness K, and that to me sends shivers up my spine, given the circumstances of this particular matter.
Senator Brandis.
Well, Senator Xenophon, as I'm sure you know, the case to which you referred has been the subject of investigation. As you know, search warrants were executed. It would be absolutely wrong of me to respond to that which you seek from me, particularly as it would involve, among other things, interfering with the discretion of the Commonwealth DPP. Absolutely wrong of me, and I will not be drawn, Senator.
Senator Xenophon.
Through you, Chair, I understand the attorney's propriety in the sense that how he and I respect that. but the attorney still has the ability to consent or not to consent to a prosecution. He is, in a sense, the final safeguard or arbiter in these matters after getting advice from the DPP, the Commonwealth DPP. I have a very deep concern that the fact that the attorney cannot rule it out means that this piece of legislation could extend to Mr Cleary or Witness K, who I understand was a former senior ASIS officer, and I don't know who that person is. In fact, I never want to know who that person is, who has made serious allegations about the conduct of ASIS in terms of the bugging of the East Timor cabinet room during very sensitive negotiations. It is, I think, one of the biggest spike scandals in this country in a generation, and I'm concerned that somehow these two men, Mr Cleary and Witness K, could be caught up in this legislation, and at least one of them could face a stripping of their Australian citizenship. I don't think that's what the legislation was intended for. That's not what the former Prime Minister said or the Immigration Minister has said. And I think it's very important that we have on the record that Mr Cleary and Witness K may well be in the firing line with this legislation.
Senator Brandis.
Senator Xenophon, the legislation will operate according to its terms. The legislation was not introduced into the Parliament, is not being discussed tonight with any individual person in mind. The legislation is designed to declare that certain consequences will follow or may follow from certain categories of conduct which are inconsistent with allegiance to Australia. Now, Senator Xenophon, in order to reassure you of that, might I remind you that the submissions to the International Court of Justice by Mr Gleeson, from which you have read, were made some while ago, I think in early 2014, in January of 2014, well before the time at which this legislation was even contemplated.
Senator Xenophon.
For the record, Madam Chair, I'm not suggesting the legislation was contemplated as at the 21st of January 2014, but what I'm suggesting is that, given Mr Gleeson's comments, his submission to the International Court of Justice, given this legislation, if you add one and one together, you can get two, which is that potentially they could be caught in the firing line of this. And I just make the point that the espionage provisions, and that's what we're relating to here, and I think that I want to make it clear that Mr Cleary, who has not asked me to ask these questions, who is distressed at any allegation that he could be could have breached Section 91(1) as a proud and patriotic Australian, that the espionage provisions were never mentioned in the selling of this bill. They weren't. I've gone through transcript after transcript where it was not mentioned, and furthermore, the attorney has not repudiated the fact that these two men, Witness K and Mr Cleary, could be caught up in this bill, and at least one of them could face the stripping of their Australian citizenship.
Senator Brandis.
Well, Senator Xenophon, I won't comment on an individual case where there has not thus far been a prosecution. It's just not appropriate for me to do that. The legislation applies to the conduct defined in it, and where a person has engaged in that conduct, then the consequences that the legislation provides for may follow. They don't necessarily follow because there is a ministerial power of excusal in relation to sections 33AA and section 35, and there's a ministerial discretion to be exercised under section 35A. But the consequences may follow where conduct is engaged in of the kind described by the legislation.
Senator Xenophon.
And perhaps the attorney can correct me if I'm wrong, but it is my clear understanding that Mr Gleeson SC, the Solicitor General, has not withdrawn, repudiated, retracted or in any way resiled from the comments that he made before the International Court of Justice in The Hague on the 21st of January 2014 in terms of the statement that he made effectively that Mr Cleary and witness K could be subject to a prosecution under section 91(1) of the Criminal Code.
Senator Brandis.
Senator Xenophon, Mr Gleeson didn't make comments to the International Court of Justice. He made submissions. He made submissions as his capacity as the lead advocate for Australia in those proceedings. And those were submissions as to the potential offences that may have been committed by Cleary and witness K in the event that certain facts were established. That's all.
Senator Xenophon.
And is the attorney aware whether, and I'm sorry, it's, the only court work I do nowadays is pro bono work, usually involving poker machines, so I should have used my terminology more precisely. Is the attorney aware of any submissions made by Mr Gleeson to any tribunal that would in any way resile from what Mr Gleeson said on the 21st of January 2014, where he said that there are, quote, reasonable grounds to consider that the materials over which Timor-Leste asserts privilege may include written statements or affidavits by a former ACIS officer made to Mr Cleary on behalf of Timor-Leste disclosing national security information of Australia. And he says, if that be the case, those disclosures would involve the commission of serious criminal offences under the law of Australia, and he then goes on to reference section 91(1) of Schedule 1 of the Criminal Code of the Commonwealth. Has Mr Gleeson, in any submissions subsequent to that time, in any way withdrawn, resiled, qualified, or in any way clarified those statements that he made at that time?
Senator Brandis.
Senator Xenophon, it's a completely absurd question with respect, because the issue has not arisen in judicial proceedings, internationally or domestically, since January of 2014, so no occasion has arisen. Mr Gleeson is the senior legal representative of the Commonwealth of Australia in proceedings in the High Court and, on this occasion, in the International Court of Justice. He made some submissions on the consequences for Australian domestic law in the event that certain allegations were established. Those submissions were correct. If the elements of a particular criminal offence were in a given case established, then the person who engaged in that conduct would, at least prima facie, be considered to have committed that crime. It's no different from any other criminal offence. What Mr Gleeson was saying is that if certain facts were shown, then certain legal consequences would follow. Nothing more than that.
Senator Xenophon.
So Mr Gleeson has said those disclosures might involve the commission of serious criminal offences under the law of Australia. He said would, I emphasise the word would, involve the commission of serious criminal offences under the law of Australia. I simply make the point, I'm not sure how much further I can take it at this stage, that this bill sold to the people of Australia about involving the evil that is ISIS, Daesh, whatever you want to call them, could in fact capture a former senior ACIS officer, witness K, or a former Attorney General of the Australian Capital Territory, Mr Cleary, and that they could face citizenship being stripped because of assertions in respect of Section 91, because of Section 91(1). That's the point I make. I can't take it any further. I do thank the attorney for the direct way he's answered these questions.
Well, Senator Xenophon...
Senator Brandis, wait for the call, please. Senator Brandis.
Senator Xenophon, thank you for your complimentary remarks, but I can't let you get away with raising a false issue. This is a bill about terrorism. It's a bill about terrorism to protect Australians and keep us safe. Now, I would counsel against parsing submissions made in proceedings, quite complex proceedings. What plainly the Solicitor General was saying by the use of the word would was that in the event that certain conduct were established to the criminal standard of proof, by the way, that is proof beyond reasonable doubt, before a court, and if that conduct answered the definition of espionage in Commonwealth criminal law, then a person who engaged in that conduct and was shown to the criminal standard of proof to have done so would be guilty of that conduct. And that's a completely commonplace proposition. If a provision of the criminal law defines the elements of a criminal offence, and if a person is shown to the criminal standard of proof in a prosecution to have engaged in that offence, then they would be convicted of that offence unless they could demonstrate a legally available defence. That is nothing more than a very, very, very simple illustration of the way the criminal law operates, Senator Xenophon.
Senator Xenophon.
There are two words I've had to look up on my iPad today. The first is lickspittle in the context of the debate, the tax debate. I worked out what that was. I thought it sounded pretty rude. It wasn't quite as rude as it sounded. And I had to look up parsing, which Wikipedia kindly says parsing or syntactic analysis is a process of analysing a string of symbols, either in natural language or in computer languages, conforming to the rules of a formal grammar. The term parsing comes from Latin pars, orientationis, meaning part of a speech. There is, and I thought it was a garnish, I suggest to you that what is happening here, there's no parsing here. The fact is, this goes much broader than the people of Australia were told. What concerns me is that two people involved in either exposing or one of them representing someone who has arguably exposed one of the biggest spy scandals in this country in a generation, if not longer, could face having their citizenship stripped because of this. And I can't put any higher. This seems to have gone beyond this. This was a bill presented to the people of Australia about terrorism, but instead other provisions that relate ostensibly to espionage could include this. Attorney, I am grateful for your responses. I don't think I can take it much further.